So if we are, there we go. We are live. Good afternoon, and thank you all for joining us for episode number 53 of At Your Service with Haber and Martinez. As you can tell, Martinez isn't here, but this guy over here, Brian Chase, is our special guest. Ed had some technical difficulties, as did I. I apologize for the late start, but wouldn't you know, the one day that we have a guy to talk about, an IT expert to talk about tech issues, we would have nothing but tech problems. That's the way of the world, right? Anyhow, today's episode is entitled Electronic Evidence: Your Tech Can Either Screw or Save You. And we are honored to have Brian Chase with us. Brian is a attorney. He is an adjunct professor at the University of Arizona, and he is also the director of digital forensics at Archer Hall. Archer Hall is a nationwide forensic data collection, analysis, and expert witness testimony service. They specialize in forensic imaging of any and all tech. They do data recovery, location, analyzing, and preservation of electronic evidence. And most importantly, they ensure the admissibility of their work product by way of expert evidence analysis and in-court expert testimony. So Brian has found a niche in the law that gets him out of having to do the day-to-day grind like suckers like myself have to deal with. And I met Brian vis-a-vis a couple of seminars that I attended that he put on. After the last seminar, which I enjoyed so much, I reached out to him and asked if he would be kind enough to consider coming on the show to talk to you guys about some of these things that affect your everyday life that you may or may not be aware of, which can certainly affect you in a courtroom, be it civil or criminal. And he was all too eager to say yes. So apart from being very intelligent, informative, and entertaining, he's also quite altruistic. Brian, thank you so much for coming today. I really do appreciate your time and your effort. And I welcome you to At Your Service with Haber, albeit no Martinez.
Thanks for having me. Excited to be here.
So I thought we could talk today about the last seminar of yours that I attended was entitled Your Home is Spying on You, a look at the Internet of Things Forensics. And it was really just, really enlightening for me. I'm a technological T-Rex. I'm a troglodyte, as you know from the last 10 minutes of just trying to get my camera working. It's hard enough for me to power on my phone in the morning, much less troubleshoot these types of things. But when I went through this, listened to your seminar and participated in it, and I learned about things that I never really thought about, like these, well, we use the word things that you have in your home. Most of us know that our phones and our computers have web browser history and app data and stuff like that. And whether we think about it or not, our eyes and ears and minds can be open to the fact that there is an electronic evidence trail created by all those things. And those are the traditional things that we think of, right? You're out drinking with your buddies and you're taking pictures of doing shooters, and then all of a sudden you get a DUI later that evening and the prosecutor scours your social media and there they have you 2 hours earlier pounding shots, standing on a table half dressed when you're telling the police, slurring to the police officer on body camera, no, I didn't have anything to drink, or yeah, I just had a beer with dinner, right? But you showed us some stuff that was really fascinating. And if you could, maybe talk a little bit about that, that would be great.
Yeah, I mean, there's so much more out there now that's tracking us. So it's kind of a scary presentation because it's revealing about all the stuff we're sticking in our homes that's tracking what we're doing every day. Things like your Amazon Alexa, your Google Home, Nest thermostats, Philips Hue light bulbs, Ring video doorbell, all these smart devices in our home, they're all tracking lots of data. And this data started to be used in litigation a little while ago. The first cases that I saw where this data was used started around 2015, so about 7 years ago. It was probably in some cases before then, but started making national news in about 2015. And that's when we started seeing law enforcement looking at these devices to investigate cases. And since then, there's been an explosion in the use of this data in court. Civil cases, family law, criminal cases, it is all over the place because these smart devices are just everywhere. And I suspect, we've got A month away from Black Friday or so. That's where we're going to see a whole bunch of these things go on sale. They're going to be given as Christmas gifts again this year. We're just going to see more and more of this stuff in the coming years.
Well, I can tell you that for me, Ring doorbells have become an incredible source of data in my criminal cases. We wind up with a lot of stand your ground claims here in Florida, which I don't know how familiar you are with stand your ground, but it's basically self-defense on steroids. And, I don't want to say cops do a sloppy job, but many cops do an incomplete job. And I understand it. I mean, they're just dispatched to a crime scene. We're not talking about homicide cases. These are run of the mill domestic cases or assault cases or road rage cases. And all of a sudden you find this Ring doorbell video that turns a totally different light on the perception or belief that the police have given to the credibility of the people who speak. Maybe one of them didn't say anything. Maybe one of them said something that was inaccurate. But in your presentation, we were talking about stuff like Fitbit and pacemakers and just all sorts of stuff that are so outside of the realm. Roomba, I thought was fantastic. So maybe I did highlight and note the three of the cases that you talked about during that presentation, and maybe we could educate the audience a little bit by discussing the Bates case and the debate case, as well as Mr. Compton.
Sure. Yeah, the Bates case was kind of the first case to make national headlines involving this kind of data, and it started with an Amazon Echo. What happened was Mr. Bates he lived in Arkansas. He was watching football with his buddies. Next morning, one of his friends, Victor Collins, is dead in his hot tub. So they call 911. Police arrive and they look at this scene like it's a crime scene. They see broken beer bottles and there was a broken doorknob. There was blood spatter near the hot tub. So the body goes to the medical examiner, who then rules it a homicide. So now they're dealing with a homicide. And they search the home and they find this Amazon Echo. So they send a warrant to Amazon saying, we think you've got data related to this, this homicide. Give us the data. Which was a little interesting. It was at least the first national one to make the news about a warrant going to Amazon for this kind of Amazon Echo or Alexa data. And Amazon decided to fight it. They said, no, we're not going to turn it over. This speech is protected by the First Amendment. So, if our Amazon Echo recorded any audio in that home, that audio is protected by the First Amendment. You need a compelling reason to get this. You can't just, you need to show a higher standard to get that data. And Mr. Bates decided it wasn't worth fighting. He just agreed to turn over his data. So Amazon turned over the data, and turns out there was nothing. But that's where the news really started, was with Amazon, kind of fighting this, and the police searching for this Amazon Echo data, and there was nothing. But what didn't make a lot of the national headlines was all of the other data they found after the fact. There was more smart home data that was used in that case. So Mr. Bates ended up gets prosecuted for the murder of Victor Collins. And what happened was there was a smart water meter that had been installed on his home. And that water meter measured the water usage of the home down to the hour. Every hour it was measuring how many gallons of water was being used. And, when they were watching football the night before, they were using about 10 gallons of water an hour. But when it got time between the hours of like 1 and 3 a.m., they used 140 gallons of water. And if you remember, Victor Collins, dead in a hot tub. So police think, well, they drained the hot tub. They killed him in the hot tub. They drained the hot tub. They refilled it. Or they just used water to wash away the signs of the blood near the hot tub. So not Victor Collins, Mr. Bates is prosecuted for the murder of Victor Collins based on this smart water meter data. But it turns out there was even more. They had more than smart water meter data. So, Mr. Bates, his defense team start looking to the case. And this is the news, I think, got this wrong. But what the news reported was that he had a step counting app on his iPhone. So, just when you look at your phone, you can see how many steps you took during the day. And that showed that once he went to bed, he didn't get up again. He slept through the night. So he couldn't have done it because he was asleep. Now, I don't think that was a step counting app. I think everybody could kind of realize, well, what if he just took his phone out of his pocket and set it down? It's not going to count steps. What likely happened was he was probably wearing something, maybe an Apple Watch, a Fitbit, something like that, that was actually tracking his steps and also tracking his sleep, so that it showed that he didn't remove that device and showed that he was asleep. I suspect
But
that's what happened.
how could it also not make the same argument that he wasn't wearing it at all and it was a Fitbit that was just sitting on the tabletop?
Because if it's a Fitbit, it's going to be tracking things like heart rate. So it'll know if you take it off because there's going to be a gap in data. There won't be a heart rate.
So
And
that particular device was able to show that it registered a heart rate during those hours as well as no movement.
that's what I think happened. The news didn't really get into the details. And as a result of that data, they actually dismissed the case. So I think it had to have been more than just a step counting app in order for a prosecutor to say, yeah, I'm going to drop the charges here. I think it had to have shown something like heart rate and no steps in order to prove he could not have done it.
So I'm assuming they had no other tangible evidence or any other corroborating evidence. In other words, none of the other guys at the party said, "Oh yeah, they were fighting that night," or he had said, "I'm going to kill him," or anything like that. There was nothing circumstantially to tie him, and so that defense evidence was very helpful in getting that case, a murder charge, to disappear.
Yeah, I mean, if it shows that you're asleep, how could you possibly have committed a murder if you're asleep at the time?
Now,
So pretty compelling evidence.
if it's a Fitbit or an Apple Watch, those are time stamped and date stamped as well, correct?
Correct. Yep.
So there's really no arguing, and you can't manipulate that, or can you? I mean, is there a way for me to program it or manipulate it so that or is there a reasonable argument that the government might be able to make that I attempted to do that?
You could. So most of these smart devices get their time from the phone. So like I have a Fitbit on right now. My Fitbit is getting its time from my phone. So if my phone is not using the correct time, then my Fitbit would not be using the correct time. But when you're looking at a cell phone, you might be able to tell if somebody had been altering that time to see had they messed with it, had they changed the timestamp in order to kind of hide what they were doing or make it look like they were doing something else at the time.
So if you were hired by the defense in this type of a case, I'm assuming that your Archer Hall or your experts or your technicians or whomever would be digging through this, anticipating those types of arguments by the government, right? You would want to dot those I's and cross those T's so that you could say, well, here's the data and here's how we know the data has not been compromised.
Yeah, I mean, the biggest thing that we're going to do in something like that is we always want to take the data and match it up to something known. So, let's say we're looking at, text messages or something, and we've got a security camera video. Maybe it's a Ring doorbell video of somebody, holding their phone and texting. Maybe we can match up the time of that text with the video, something else external that gives us another layer of kind of credibility for that data. If we can take a known point in time and match that up with the time on the phone, then we know everything's set correctly.
Not to run off on too much of a tangent, but we get a lot of body worn camera footage in our cases here. Most of the police departments, most of the officers are equipped with body worn. So it is very routine for me, especially with the Metro-Dade Police Department. And I honestly don't have an answer for the why of this. But the time stamps on the video never match the actual time of the incident. I don't know if they're operating on Zulu time or Pacific time or who the hell knows what. Maybe it's just where the company that created them or processes them is based in a different time zone. But clearly we know when the officers were there when we match them up to the CAD reports, right? So if I'm cross-examining an officer and I want to use a piece of body worn, the timestamp on it almost never matches the time frame where they're actually there. Yet it's undoubtable that that officer is at that scene because you can see it.
Right. Yeah. So you can take that and you can kind of then you've got a known point. So you know like when they arrived based on other data. And then you could kind of figure out what that conversion should be from real time to what it is on that body cam because you take one known point. That's the same thing we're going to do with digital evidence is take a known point where everybody agrees like this happened at this time and then make sure all the evidence kind of syncs to that known point.
Awesome. What about Mr. Debate?
Mr. Debate. So this time you got some Fitbit data that's maybe not so helpful. This is a guy in Connecticut, also in 2015, who calls the police after a home intruder, home invasion. And he says that this home intruder, this invader, comes in to rob him, and shoots and kills his wife, zip ties him to a chair, cuts him with a knife, and ends up stealing like his wallet and credit cards. So police look into this, and they're pretty skeptical of Mr. Debate. His timeline doesn't make sense. Also, why was only like a wallet stolen after they murder his wife and cut him with a knife? And the knife wound was kind of superficial, so they were like, this stuff doesn't add up. So they start looking at what happened to his wife, and she was wearing a Fitbit. And according to the Fitbit data, she was alive an hour after she had been shot. She was up and walking around. So unless she was moving around and walking around for an hour after she had been shot, something was wrong with the timeline. So they start looking into other devices as well: home alarm sensors, phone activity, Facebook records, just all sorts of things. Established that she was alive well past when he claimed. And he ended up getting prosecuted for the murder. Turns out he was having an affair at the time. He had lied to police about having an affair. And so they kind of do a full investigation of the case, end up charging him. And his case actually went to trial earlier this year, and he was convicted of the murder of his wife. And Fitbit data was one of the big reasons behind it, is that it completely discredited him in his timeline.
Now, in this case, it was the government that secured that data, as opposed to the defense volunteering it as exonerating or exculpatory evidence, right?
Right. Yeah. It was the law enforcement that had investigated it. They're the ones that pulled that Fitbit data.
And how did they get that? They submit a subpoena over to Fitbit Corporation and say, hey, give us the information on this particular unit?
I'm not sure how they did it in this case. There's generally one of two ways to do it. So your Fitbit's going to sync with your phone. You set up a Fitbit by installing a Fitbit app on your phone, and then it kind of syncs, just like your Apple Watch syncs with an iPhone. So what they could do is they could get the data directly from her cell phone. So if they seized her cell phone and then extracted the data from her cell phone, they might have got the Fitbit data there.
As a quick aside, how about getting into cell phones? I mean, I think the law is pretty settled that you're not under any obligation as a citizen to provide your passcode to the police. They can take your phone. They can, they can take possession of it. They can do it by way of a subpoena, or they can just physically grab it from you. However they seize it, they seize it. But if they say to you, all right, hey, Brian, I need your passcode, you're perfectly free to say, I'm sorry, I need 6 winning lotto numbers. When you give me those and I cash in my ticket, I'll be happy to give you my passcode. Or, I'm just obviously being facetious, but my point being, you don't have to give it to them. So you don't give them the code. Can they get into that phone? Because, I know that there was a case not too long ago where, where the FBI tried to get Apple to get into a phone, and Apple told them to go pound sand. And this is a serious case. It was a terrorism case. They didn't want to give the information out.
Yeah, San Bernardino shooter. And FBI ended up dropping that case because they got into the phone without Apple's help.
So they can. At the end of the day, now we're talking about the FBI. What about, Mayberry RFD?
So many law enforcement agencies have the ability to bypass the PIN or passcode of phones. There's two companies out there that sell that capability to law enforcement, and a lot of jurisdictions have that now. And even if you're dealing with kind of some small jurisdiction that maybe can't afford it, they might have a partnership with
they'll
a federal
piggyback
agency that can do it.
Right. Yep. They'll piggyback with another, Homestead Police will go to the Florida Department of Law Enforcement, or they'll go to the FBI or what have you.
Exactly. So they can bypass pins or passcodes on most modern phones nowadays.
And would the same hold true for other encrypted devices?
I guess it would depend on the device.
Or what about apps? Like, for example, WhatsApp is supposed to be encrypted. Is it?
Well, it's what's called end-to-end encrypted, meaning it is encrypted in transit. So while it travels over the internet, it's encrypted. But if you can see it on your device, then law enforcement can probably see it on your device because it's not encrypted there. Now, take a step back, though. You can add additional layers of security. So, for example, on Signal, another encrypted messaging app, you can add a PIN or passcode to that app, and that might prevent law enforcement from being able to see the data inside that app.
But as a general rule, once you hit send and it's received, there's a trail.
Correct. Yeah, it's on two different phones, and they could probably get it from at least one of those two phones, if not both.
So we'll come back to that. We'll come back around to that in a little bit. Let's talk about our pacemaker friend, Mr. Compton.
Yeah,
Because
Mr.
I
Compton.
love this one. This is just, you can't make stuff like this up.
Yeah, it was an interesting one when I stumbled across this one. So Mr. Compton is an elderly, kind of out of shape gentleman living in Ohio, and his house catches on fire, burns down. But before it burns down, he's able to pack several bags, a suitcase, get it all out to the curb. Now remember, elderly, not in shape man, packing all this stuff up while his house is on fire. So police were pretty skeptical that he was able to do all of this as his house is burning to the ground. So they get a warrant for his pacemaker data. He has a pacemaker in it. So they get a warrant to get the data from his pacemaker. The cardiologist reads that data and says, no, that's not what happened here. Now, we don't know the exact details of what the cardiologist saw, but we could probably guess. Presumably, he didn't have a heart rate spike when his house was burning down, consistent with like frantically trying to pack bags and get him out to the curb. So what looked like he probably was much more deliberate, packed everything, then set his house on fire.
So,
and he ended up getting charged with arson.
a quick question. I mean, and it just personal interest. So the cops send a subpoena to Fitbit and say, we want your data. And Fitbit says, screw you. They got a First Amendment privilege. Or maybe it wasn't Fitbit, whoever we were talking about earlier.
That was Amazon, yeah.
Amazon, right. Amazon Echo or whatever it is. Yep. No, we're not giving it to you. They have First Amendment. What about HIPAA? What about any privacy interest with regards to your medical situation? What gives law enforcement the right to subpoena that information?
Well, I think one, it'd be the distinction between a subpoena and a warrant. So subpoena would probably be difficult, but a warrant had to get authorized by a judge. And so I think that would be part of the distinction there. I've never really researched where HIPAA and warrants intersect, but certainly I've seen plenty of cases where law enforcement has obtained medical information using warrants, and probably because it's going through a judge and authorized through that warrant process. There's probably protections in place there or exemptions under HIPAA, but I haven't had to research.
And I would guess that doctor, two things. One, that doctor probably did not lawyer up him or herself and go to an attorney and say, move for a protective order, doctor-patient privilege, blah, blah, blah. Or alternatively, the subject himself or herself, in this case himself, Mr. Compton, was probably never noticed, right? So he didn't have the ability to try and prevent the government from doing that ex parte. I mean, no doubt they didn't ask him for a HIPAA waiver, or maybe they did.
Yeah, I doubt it. I suspect that they went to the judge, they got the warrant. And I also suspect the cardiologist they used was not his primary care doctor. But who knows? Maybe they did go back to his
but they still had to get that. They still had to get that data, right? I mean, the pacemaker, I guess they would have to have either a serial number or a patient's name or some sort of correlating information. How could they possibly know what his pacemaker identification number is without getting into his medical history?
That's a good question. I don't know what the procedure involved was. Maybe they got a warrant that ordered him to show up to a hospital so they could pull his cardiologist data.
It could be. It's interesting. But the point is, here is a case where this was made and broke on his pacemaker, correct?
Absolutely, yep.
Fascinating. You have any other interesting cases that you want to bring up that we haven't talked about?
I think there's a good one out of, what was it, North Carolina, I think it was. It was Nicole Vanderhayden, where she was found strangled to death and her body was disposed of in a field. And the night before, she had been at a concert with her boyfriend, Doug Dietrich. And they get into a fight. Text messages show they get into a fight. She's accusing him of cheating on her. And of course, the next day, her body's found. So what do the police do? They look at the boyfriend, especially after looking at those text messages. So they charge him. Trying to remember if they did. They arrested him. They charged him with the murder. But he had Fitbit data that showed that he went to bed that night and he only got up a couple times. He had to go to the bathroom, things like that. But he had more data too. He also had a device in his car that used GPS and cellular connections. Basically, when he drove his car, it would send his location up to, in this case, his insurance company.
So that's
And
kind of like the progressive snapshot or whatever it is.
it's exactly that. Yes, it was progressive snapshot in that case. So this little device plugged into the car's OBD port, a little diagnostic port under the steering wheel, and it showed his car didn't move. So he didn't get up much. His car didn't move. How did he kill his girlfriend, and get her body to a field without driving his car, without having an elevated heart rate, without taking steps? He was asleep most of the night, and the Fitbit showed he was asleep. So police keep investigating this case, and the DNA evidence comes back, and it points to a different man, a guy named George Birch. And police start investigating Birch, and they get his Google location history. So what happens with Android phones and some iPhones, depends on how you set it up, but Google tracks the location of Android phones. So they go to Google with a warrant and say, give us the location for George Birch. And Google produces all this location data showing Birch basically following Miss Vanderhayden home and then taking her body to the field where it was disposed of. So he ended up getting prosecuted for the murder of Nicole Vanderhayden. And the other data, the Fitbit data, progressive snapshot data, kind of exonerates the boyfriend, Doug Dietrich.
So we have at play a double dynamic there, right? You've got the government. Well, first you've got the government going after the obvious target. That target then presents exculpatory evidence in the form of electronic data to law enforcement that says, look, it couldn't be me, and here's why. Here's the proof. And that leads them to do a further investigation to corroborate or dispel the defense allegations, where they secure additional electronic evidence combined with scientific evidence of DNA, and they're able to find that it's another individual. So in that last case, that North Carolina case, you've got electronic evidence doing both. You've got it setting you free and screwing you, depending on which side you are.
Yep, absolutely.
Fascinating. Any others, or those are the du jour cases?
Those are my favorites. I mean, there are tons of cases out there. I could give you one more here. That's a good one. This one's not from the U.S. It is from the U.K. So, man is shot and killed with a crossbow. Yeah, UK, not US.
Right, because you can't get guns in the UK as easy as you can here.
Right. So,
but crossbows and axes, no problem.
Right. So, what happened was, he's watching TV. His TV signal goes out, just loses connection. So he goes outside to check out his satellite dish and see what's going on. While he's checking his satellite dish, that's when he's shot and killed with this crossbow. So police are looking into this. They develop a suspect. They interview the suspect. But about a week or two after that, they find the suspect's car off on the side of the road, and it had been set on fire, completely destroyed. And it was a Land Rover. So they went to the manufacturer. They went to Jaguar Land Rover, and they asked them to produce any data they had about that car. So Land Rover was able to produce GPS information showing that the suspect's car had driven to the victim's home before the murder, and that the trunk of the vehicle had been opened for 39 seconds prior to the murder. They matched that data up with when the satellite signal went out, because what happened was, the reason the satellite signal went out, the cable from the satellite dish into the home had been cut. So they got the data from the satellite company saying this is when we lost connection to our customer, and that was after the car arrived, after the trunk had been opened, and they used that to kind of develop their case against the suspect here and prosecute him for murder.
Fascinating.
Yeah.
So electronic evidence. When we talk about electronic evidence, we're talking about anything in any kind of digital format, right? So things that we just discussed here, and I want to talk about a few of them, that people may not, necessarily think of, like electronic locks, say in a hotel room, where they give you that little credit card type thing that you have to swipe to open up the door as opposed to a physical key, right?
Yep.
Or smart locks that we have in our houses now, right?
Yep.
You have smart speakers. You have Nest thermostats. Tell me something about a Nest thermostat.
Yeah, so they're tracking all sorts of data. So the Nest thermostat, the smart thermostat, Nest is a Google product, acts as a thermostat, but it also can learn your patterns. Like it will pair with your phone to learn where you are. So if you're not at home, it can heat or cool your home to save you money on your energy bill. So it tracks that. It tracks when you're home or not.
So if you have, like, let's say, a lot of people have video surveillance in their home, right? Some people may have pets or elderly individuals or handicapped people or, whatever things that they are concerned about, or people or pets that they're concerned about. So would the same type of thing apply there, with your cameras when you're checking them on your cell phone, location tracking, all of that sort of stuff?
It could. It depends on the camera, what you're using, which product it is. So some of them might be able to sync to your phone and know like where you are. Some of them are just going to be recording, the video and nothing really more. It just depends on the brand and what it can do.
So when we think about electronic evidence, the layperson, most of the times we're just thinking about our phones and our computers, right? And so I get asked a lot, well, what if I just destroy my phone? That's the end of that. I just, pull a Hillary, take a sledgehammer to it, and that's the end of it. Is that the end of it?
Probably not. So you got to think about how much of this data goes up to the cloud. If you use an iPhone, is your iPhone backing up to the iCloud? Well, if you smash your iPhone with a hammer and you go out and buy a new iPhone, is it just going to automatically download your last backup? Sure is. That data's in the cloud. You can download and get it there.
And there may be other devices or other apps or other things where that information has already been shared and stored, correct?
Oh yeah, I mean, there's tons of places. So, I mean, besides things that are obvious, text messages. Well, there's a sender and then there's a receiver. So there's two people that have every text message there, at least two, if not more. But then you've got your Google data, so your browser history from Chrome, your search history, all that stuff is up in the cloud. All your Amazon data is in the cloud. Facebook and Instagram together, Twitter, all that stuff's in the cloud. It doesn't sit on your device. So destroying your device does nothing to get rid of that data. It's all up in the cloud.
You destroy your device, and law enforcement now cannot crack open your cell phone that they can't physically access. How do they get to your cloud? They got to go through the same warrant or subpoena process through Apple?
Yeah, they get a warrant, they send it off to whichever company and go request the data that way.
And these companies, are they, putting up any fight with regards to turning this information over to law enforcement?
For law enforcement, not really. Most of them are cooperating when it comes to warrants. It does make it harder if you're in the civil arena. So if you're using a subpoena instead of a warrant, some of the companies will fight, and there's some laws in place. But when it comes to warrants, really the companies aren't putting up much of a fight. Their only real limitation there is what will the court system allow law enforcement to get with a warrant.
So let's draw that line. In criminal cases, obviously, for the folks, so that you're clear, we're talking about mostly criminal cases here where a prosecutor or a law enforcement officer, be it municipal, state, or federal, is trying to secure information for a prosecution. In a civil case, you have something completely different. So let's say it's like a divorce case, and one party wants to prove the other party was having an affair or dissipating assets. These are completely different things. Let's say you want to, prove that your spouse is cheating on you by way of their electronics, but your spouse won't turn over their information, and you don't have their password. Not every husband and wife or domestic partner share their passwords with one another, right? So that makes it a little more difficult in that arena.
Yeah, absolutely. The average person can't just go get a warrant. You got to be law enforcement to do that. And there are protections for a lot of this data from subpoenas. So subpoenas are what you can do in a civil case, a family law case. You want to go request data from a third party, you send a subpoena. But there's a law. There's this 1986 law. It's a
The
federal
Electronics
law.
Communications Privacy Act.
That's the one. And it limits what you can get with a subpoena. So you can't just go get, somebody's email account with a subpoena. That law says you can't do it. Now, the law obviously wasn't quite written for that since it was made in 1986, but that's how it's being applied today. And so there's additional protections in place, at least for civil cases, that can protect some of our data, not all of it. Some of it you still can get with a subpoena, but like content of communications, location data, things like that, you can't just use a subpoena to get that data.
So I don't practice in the civil arena, and I'm not any kind of wizard with the rules of civil procedure, which are very different than the rules of criminal procedure. But I do know some rudimentary stuff. For instance, in a civil case, one party can send out interrogatories or requests for production to the other party. And so I could say to my, domestic partner or to my spouse in a divorce proceeding or a dissolution proceeding, please provide all of your text messages to this particular phone number. And of course, they could object and they could ask the judge to say no or whatever, but there's no subpoena involved there. So,
correct. Yep. Yeah, if you're just
that's
getting the data from the other side, you can request it in the litigation. So you can do a thing called a request for production, send it to the opposing party and say, produce your emails, your text messages, your browser history, whatever it is, as long as it's relevant to that litigation or potentially relevant to that litigation. And they can object and then it could go to the judge, but you have that ability to request data from the opposing party in civil litigation.
tell us a little bit about smart speakers.
Sure. So for smart speakers, you've got things like your Amazon Echo that we talked about already. You got your Google Home is the other big one. These things are going to track kind of everything you say to it. So they listen for that wake word, whether it's Alexa or OK Google or Hey Google, any of those things. And I'm sure I'm setting up people's speakers at home right now by saying that. But they're going to listen once they hear that wake word. They record what you say and they send that audio recording to the cloud. So Amazon has everything you have said to your Amazon Alexa, unless you've gotten in and deleted it. And so that data is sitting there and it is available, and you could go get that data. And that's exactly what law enforcement was looking for in that Bates case where we started. They wanted an audio recording of what happened in that home at the time of the murder. They didn't get one, but that's what they were hoping to find.
Now, there have been some snafus with those things too, right? Where the police are accidentally called or, something's tripped by accident.
Oh, yeah, there's been all sorts of them. Anybody who's got one of these smart speakers has encountered the issue where the speaker started talking to them and you're like, I didn't say anything to you. What are you doing talking to me? They just mishear something and then they'll record it. And so there was a case out of, it wasn't a case, but a story out of Portland. This husband and wife are talking in their home and they get a frantic call from the husband's employees saying, you're being hacked, unplug your devices, disconnect your internet. Like, what are you talking about? It's like, I just heard you guys talking about your hardwood floors. And what happened was their Amazon Echo was in the other room and it heard them say that to send a message to this guy, to this employee, which they did not say that at all, but that's what it heard them say. So it recorded their conversation about their hardwood floors and sent the conversation to the employee because it completely just misheard the conversation. And they were in the other room, so they didn't hear the Amazon device talking to them, but it could hear them and, ended up sending their conversation.
So I guess the point being, apart from a potential message to somebody else or sending something to someone else, it could inadvertently be listening and recording things that you don't necessarily know it's listening to and recording, correct?
Yep, absolutely.
And as you said, that's what the police were looking for in the first case that we discussed, the Bates case.
Yep. Yeah. Everyone who's got a smart speaker has encountered this at some point of it just like lighting up and hearing something, and then that means it recorded you.
So what did the cops do? They just throw out a fishing net in the hopes that it might have something, or did they actually have some reason to believe that it was there? Or is it just, 101 in investigative techniques these days with regards to doing an electronic evidence sweep, let's call it?
Yeah, well, in the Bates case, I think it was a fishing expedition. Their warrant affidavit just said that they have reason to believe Amazon's in possession of data relating to the case. They didn't really elaborate on that. So to me, it sounded kind of like a fishing expedition. They didn't really know anything. I do think, in order to get a warrant, they've got to show probable cause. They've got to show that there is the likelihood of finding evidence there.
Well, and don't they also, I'm sorry, I don't mean to interrupt you, but there's also a Fourth Amendment requirement for specificity.
Correct. Yeah. They can't just go and say, like, we want every recording ever said to this Amazon Echo. It's got to be specific for the needs of that case. So like for the Bates case, they couldn't be like, well, we want everything. Maybe he's had his echo for a year. We want all year's worth of recording. That's not going to work. So I don't really know how they had probable cause in the Bates case, but a judge signed off on it, and they were able to get their warrant.
That's part of what the audience should know. You don't, unfortunately, there are a lot of things that happen during the investigation of cases that are ex parte, meaning it's the government acting only on their own behest without any notice to the defense. And so, when they want your bank records, they don't call you up and ask you for your bank records. They send a subpoena over to the bank and they say, give us the goddamn bank records. And 9 out of 10 times the bank sends over the bank records without any hesitation. So that's the way these things work. It's not until after the fact that they've already gotten the records, they've already used them for their filing purposes, and they've already charged you with a crime that your defense attorney gets to go in and kind of take a 20/20 hindsight look for the issues that you just brought up, Brian, in terms of probable cause and specificity. Were those things actually met, or did the judge simply rubber stamp something without meeting the constitutional mandate? Did the judge undervalue or expand beyond what was necessary?
Yeah, I think part of the problem is judges aren't very sophisticated when it comes to this stuff. I mean, most people aren't, unless you're somebody like me that deals with it every single day. You probably have no idea. I've been in hearings where judges have suddenly realized the amount of data they were authorizing law enforcement to get, and they didn't realize before how much data they were authorizing.
Would it not be fair to say that the cops know damn well what they're asking for? They understand the amount of data that they're seeking.
I would certainly hope so. If they're the ones seeking it, they should hopefully know.
My point being, and I guess I don't mean to attribute, malicious intent to the cops, but they're looking for as much as they can get, and to some degree, I believe, intentionally taking advantage of judges who do not understand these parameters. Look, the average age of the judiciary is going down, at least where I live. You look at some of these judges and think that they're, with respect, I don't mean this to their intellect or their prowess, but they're like, kids. They're young. Compared to me, everybody's young, right? So I think the younger judges may be more tech savvy than a lot of the older ones. But then again, there's a lot of folks that are up there in years that really bunker down and have a real firm grasp on this stuff.
I don't know if age is, it certainly matters to some extent, because I think the younger generation's grown up with more of these. But, I teach kids at the law school now. They have no idea how much data is being tracked. They know much more about the devices and accounts and things like that are out there, but they're still shocked at how much data is being tracked. So even though they might be more technically sophisticated, they still might not have any real insight as to the volumes of data that these companies are storing.
Are you teaching classes in electronic evidence? Is that what your course title is?
No, I actually teach a trial advocacy course, but I do lectures every semester for the law school on these topics. So I come in and teach basic trial advocacy students about digital evidence. I usually do a guest speaker or a guest talk for students studying criminal justice issues as well, and some of these issues.
Running off on a little tangent, that's how I came to attend your seminars. Carlos Martinez, who's our local public defender, very kindly puts on at least once a month a training seminar, what we call continuing legal education seminar, for his staff. Miami-Dade Public Defender's Office is a pretty large office. I don't know how many lawyers they have, maybe 150, 200, 250. But they open it up also to the private defense bar, at least insofar as the Florida Association of Criminal Defense Lawyers Miami chapter is concerned. So I'm not a public defender, but I am a lifetime member of FACDL Miami. And because of that, I attend pretty much every seminar that the public defender's office puts on. And that's how I came to attend your seminar. So, you're providing a service not only to young would-be lawyers and college students, but to real world lawyers like me, who, mostly younger attorneys, but even guys my age and guys older than me, who are really getting an invaluable education from you with regards to opening our eyes to things that we might not have thought of. I might not have ever thought to try and exonerate one of my clients by using his Progressive Snapshot app.
Yep. Yeah, I mean, that's part of what I do is I do these talks kind of all over the country. And there's just so much data out there. And often, especially when criminal defense attorneys, when I'm talking to criminal defense attorneys, is they're used to having to deal with this data because prosecution acquired it. They used it, law enforcement got it to charge their client. They're not really thinking about it as, hey, this is data I can use to exonerate my client. And that's true with all different practice areas. People might be thinking of the data in one way, but there's many different uses for this data. It's not always harmful. It can often be beneficial to a case.
Well, like I said earlier, I found Ring Doorbell to be really beneficial to me because I've had three stand your ground cases in the last 2 years that have resulted in statutory immunity and dismissal of charges just because of the Ring Doorbell. But what I find fascinating, even more so than any of that, is I provide that to the prosecution in advance. I give it to them
Yep.
together with a written motion spelling out exactly why the case should be dismissed. And I've got to say, much to my disgust, to be perfectly frank, I have never had a prosecutor, not once, in probably, I think I've done 12, 13 of these now. Not one time has a prosecutor said, you know what, you're right, the cops got it wrong. They move forward with those hearings. And they have not won one of those hearings that I've done. We have been successful 100% of the time. Now, I don't file frivolous stand your ground motions. I only file a motion if I believe I have a good faith basis and it's bona fide. So when I have a video that shows, like I had one not too long ago of a gentleman who had a family member fly from Oregon to Miami, some 3,000 miles after threatening to do so. I'm gonna come destroy you, blah 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 blah. 147 text messages over 3 days, just blasting this guy about how he was going to ruin his life and he was coming to Miami and blah. And sure enough, he shows up at the house, and so my client opens up his front door and he's got a kitchen knife, like a chef's knife in his hand, and he's yelling, telling him, get off my property. I told you not to come here. Go away. And the guy says, oh, you're screwed now. I'm calling the police. And then I'm going to call your because my guy was on probation. And then I'm calling your probation officer and I'm going to have you violated. And sure enough, he does that. And the cops show up and they arrest my client because my client refuses to talk to him. Why? He's already been through the system. He knows better than to speak to the police. He's on probation. He knows anything he says is going to result in, further problems. He's afraid. And he figures, let my lawyer say everything for me. Well, as it turns out, he didn't even think about his Ring doorbell video. He was so wrapped up in the mechanics of the moment, it never dawned on him. But as soon as he got carted away and his wife called me and I asked, do you guys have Ring doorbell? And she said, yep. I said, send it to me. So her son, tech savvy, gets right on it. Within 30 seconds, I've got videos showing and audio also corroborating this entire thing. So we go to a bond hearing the next morning, and the prosecutor argues. I had already sent it to the prosecutor in advance of the hearing. The prosecutor argues, it's irrelevant, it's immaterial. My guy's on probation. He shouldn't be given a bond, blah, blah, blah. The judge took one look at that video and found no probable cause for the arrest. Now, the state, this is another example. They filed the case anyhow. They charged my client with aggravated assault with a deadly weapon for standing in the doorway of his own door frame of his own front door of his own house, while the alleged victim, who had traveled 3,000 miles after 147 threatening text messages, was 25, 30 feet away in the driveway, taunting him on the telephone, telling him how he was calling the PO and he was going to have him thrown in jail.
Wow.
But the state, they don't, at least in my experience, they just don't want to take responsibility for exonerating an innocent guy. They'd rather have the judge or jury do it. So it really is incumbent upon anybody who's listening, who has a defense attorney, to have these conversations with your lawyer about your case. It may be that there is no applicability. There may not be any electronic evidence in your case. Doesn't exist in every one, but maybe there is.
Yep.
Any other interesting thing? I mean, we didn't talk about Roombas or kids' toys, but maybe we got a couple minutes left. Maybe we could just hit on a few other maybe pieces of electronics that maybe folks wouldn't think of that may be critical in any given situation.
Yeah, I mean the Roomba is an interesting one, and basically, if anybody's got one of these devices, Roomba or any of the other smart vacuums, if you've got that app on your phone that you can use to control your smart vacuum, open up that app and you might see a floor plan of your home. Well, those floor plans, at least at one point, the CEO of iRobot, the company that makes Roomba, said that, yeah, they were collecting that data and they had access to everybody's floor plan. So that means if they've got that data, if they've got that floor plan, they could have to produce it if they get a warrant to see somebody's floor plan. And who knows what that could be used for? If it's maybe it's that divorce case, and you're trying to see, was my ex-spouse removing furniture from the home before the divorce. Well, that
Or
floor plan data
or
from the
maybe
Roomba
the
might help.
maybe they captured the does it include video, or it just does a map, like a map?
Just a map. Yeah, no
Okay.
video. It's just a
I
map.
was going to
Yeah.
say, because video might even be better.
Oh yeah, absolutely. But yeah, so like all this stuff that
So
connects
that
to
would only apply though if you have it linked up to an app, right? So if you have a Roomba that's not, you don't control it by your phone, is there
yeah.
any?
No, it has to be one of the Wi-Fi enabled ones, and you've got to actually like have it set up to connect to your Wi-Fi. If you don't have a Wi-Fi enabled one, and generally you're going to know by using your app, then it's not going to be. It might have a map, but it's going to be saved locally on that device. It's not going up to the cloud anywhere.
Any other interesting gadgets or devices?
Oh, there's so many. You mentioned the kids' toys. There was one by Fisher Price, is a little teddy bear looking thing, and it would talk to your kids, kind of like an Amazon Echo would talk to your kids, and it recorded what your kids were saying. But it also had built into it a camera in the nose, and hackers have like hacked these kids' toys and talked to kids through these
Whoa.
toys.
So
Uh,
that's like child predator groomer material, super benefit.
yep.
How
Yeah.
do
I
they
mean,
hack into that? How does that happen?
well, a lot of these toys are not very secure. I mean, we've got all these companies now making, these digital online products, but they don't really have any experience dealing with security. It's not like a product from Microsoft or Apple or Google. And even those, like, think of how often you get an app update or your iPhone updates, or your Android phone updates to fix a security problem. And these are people who, know how to deal with security, and even they can't get it right 100% of the time. And you're asking Fisher Price, yeah, how many qualified engineers do they have at Fisher Price that deal with data security?
So
So you run into those issues.
I guess if you're a child predator or some sort of, molester or freak like that, you're hanging around Hasbro waiting to see who buys these, or toy stores waiting to see who buys this stuff and following them home. I mean, how do you even know how to access it? How would you know how to get your control of a random device?
Well, so for a lot of these, they're internet connected. So you can be sitting anywhere. As long as you got that internet connection, you can just search online for these devices. There are tools out there that hackers use to find these kind of devices on the internet. But
Wow.
some of them are like Bluetooth, and so you have to be within distance. But if you're like in an apartment building, think of how many Bluetooth devices in nearby apartments you can see from inside your home.
So
That device is vulnerable.
tech savvy criminals really have it good today. They're like living la vita dolce.
Yeah, there's a lot of stuff out there that they can get. That's why we see stories, almost weekly now of data breaches, of things hackers have gotten a hold of,
Wow.
ransomware, all sorts of stuff is out there.
Brian, you are illuminating. I mean, it's really amazing. It's hard for me to wrap my brain around. You've probably forgotten more than I ever knew about this topic, but it's really just a fascinating subject, and I could understand, why it would be very popular for you to lecture on, both academically and professionally, and in court. Not just in terms of teaching, but in terms of actual courtroom experience. Before we wrap up, let me plug a little bit for Archer Hall. Tell the folks a little bit about your company and what you do and how they can get a hold of you. I know we're scrolling your information on the bottom of the screen, but just so the folks have a good understanding.
Yeah, so we're a digital forensics firm. That means we work for lawyers in cases involving, in litigation. So any type of case that's in court, if there's digital evidence, it needs to be collected, analyzed, testified about. That's what we do every day. We can be contacted. If there are lawyers out there who want to use us, they can reach us at www.archerhall.com. There's a form on our website. You just fill it out, submit a case to us, and we'll be happy to talk to you about it. But that's kind of what we do every day, whether it's civil, family law, criminal. All we deal with every day is data and litigation.
So you don't work for private citizens, only for attorneys?
Only for attorneys. That's basically due. Most states have a private investigation law that says what we do is private investigators, unless we work for an attorney. And instead of trying to get private investigator licenses in all 50 states, we just work for attorneys.
That makes an awful lot of sense. So I use an investigator to do a lot of things for me because then I'm not attached to it, right? I mean, if I go and take my own photographs of a crime scene, I have to authenticate those photographs, which I can't do as an advocate. I can't be a lawyer and a witness, right? So that's, I guess, where you come in with regards to electronic evidence. So would you also serve in the capacity of experts to debunk law enforcement work? Let's say, for example, we want to argue, let's say we're dead in the water on a case. You know, you've got some cases as a defense attorney, it's just a dog with fleas, right?
Yep.
But our fallback is always reasonable doubt. We want to show the cops didn't do X, didn't do Y, or did Z, but they didn't do it right. Will you guys go back and do like a digital autopsy on a law enforcement investigation and be able to provide expert testimony as to how the cops got it wrong or what they failed to do or why it's possible that something else may be viable? Because all you need for reasonable doubt is some sensical reason that the jury can hang its hat on, or even one juror can hang his or her hat on, that says, you know what, I'm just not quite there. This is irking me. This is bugging me. And what better way to do that than to have somebody from Archer Hall come in and say, well, let me tell you, the cops didn't take a look at the progressive snapshot, because if they had, or they didn't check the Roomba, because then they would have known the floor plan was.
Yeah, we do a lot of that. That's actually how I first got into this field, is that, I was doing work as a lawyer, and the public defender's office called me up and said, hey, you're a tech guy. You know this stuff. Can you look at this case for us? And I looked at it and I said, oh, yeah, it looks like law enforcement did X, Y, and Z, but they didn't do A, B, and C. And they said, great, you want to testify about it? And that's kind of how I got into this field. So we do a lot of criminal defense work. Sometimes it's finding that data to exonerate. Sometimes it's just saying, look, the police missed this, and now we're getting the case 2 years later. The data's gone, and we can't go and get it now. Police should have got it in the first place.
That's reasonable doubt.
Yep.
That's reasonable doubt. Well, Brian, thank you again so very much. I really appreciate your kind time. I know you're very busy. Sharing your expertise with the audience was a really altruistic and wonderful thing for you to do. I am much obliged. I'm sorry you didn't get to meet my co-host Martinez, but on the other hand, it's probably better that you didn't, because this was a nice, smooth show without Ed interruptions. All due respect and love to my partner and my broadcast partner. Anyways, thank you again very much for your time. I hope that if we have another opportunity, you'll come back. And in any event, I wish you all the best with your pursuits. I want the audience to, again, remember that you can get a hold of Archer Hall, at any time through www.archerhall.com. And they are your electronic evidence gurus. Go to, have your lawyer reach out to them. Don't do it personally, because we need to do it the right way. Attorney work product. All righty.
Thanks for having me.
Thank you again so much, Brian. I really appreciate your time. Take care, my friend. And thank you, folks, for joining us for episode 53 of At Your Service with Haber and Martinez. Hopefully, we'll see you next week with episode number 54. Take care and have a great day.